Good morning, everybody. I'm Teresa Harvey, and welcome to another program sponsored by the North Orange County Chamber of Commerce. We're so pleased today to have an expert who many of us are familiar with, Terri Olson of HR Prescriptions. Terri founded the company in 2000 with the purpose of helping small and mid-sized employers meet the complexities of their human capital. We certainly all can understand this now as we begin to navigate the new laws in the state of California and the federal regulations that continue to be laden upon us. Let's stay up to date and have an opportunity now to have Terri tell us everything new that's going on for 2021. Terri, welcome.
Thank you, Teresa. I hope everybody can hear me okay. When Teresa says I'm the expert, it's like, wow, I really felt like an expert after numerous years in HR, but this year 2020 has tested us all on how much we really know, because we obviously had to deal with things that we never had to deal with before. We had no experience in, so it's been a very interesting time. But today I'm going to talk about the laws that are in effect. Some of them went into effect in 2020 that you may or may not know about, and then some that are effective in 2021. So this is what we're going to cover today. The CARES Act and the FFCRA, whether it's continuing or not, what parts are continuing, the Cal-OSHA's emergency temporary standards, AB 685, which is COVID infection prevention and reporting, SB 1159, the workers' compensation presumption, SB 1383, the California Family Rights Act expansion, AB 979, underrepresented community board member requirement, SB 973, the California paid data recording, and AB 1963, HR as mandated reporters. Then we're also going to cover AB 2992, crime victim leave expansion, social media policies, minimum wage increases, computer professional minimum wage increase. I'll give you a resource for the state and federal posters, which obviously is the chamber. And this is, and then I'm not going to do expectations for 2021. So I don't know why there's a little strange thing here on the last two. So I did this with my attorney last week, and I don't know why those 2 pages are still there. So let me go through this get started right away. So the CARES Act, if you probably are all very familiar with, gave this the Families First Coronavirus Response Act. And so that was started in on April 1st of 2020, and it ended, most of it ended on December 31st, 2020. And it provided an expansion to FMLA, which is the Family Medical Leave Act, which is a federal leave act. And it gave employees time off for school closings, if they were self-quarantining, if they were ill with COVID, and they called that the Emergency Family Medical Leave Act. So pretty much every employer had to comply with that. There were some exceptions like hospitals and doctors' offices and stuff. And then it also required emergency paid sick leave, EPSL, up to 2 weeks or 80 hours for people who had experienced one of those 6 requirements or eligibilities that they offered. And so that is what we've been dealing with since April. And that ended on 12/31. However, they did extend the tax credit that went with the emergency paid sick leave. So you as an employer can decide whether or not you want to continue providing employees with EPSL starting January 1st, extending that. You will get a tax credit through March 31st. But you don't have to offer that. It's just that if you do it, you have to do it for everybody, not just certain people. And so employers can extend that or not, take that tax credit. And then this is the law firm that I work with, and I'm sure Teresa can share with you other law firms that are that are maybe even members. You can support members. This law firm, Payne and Fierce, is in Irvine, and I've worked with them for 20 plus years. So that's why I just left that website for you to consider looking at, and they have tons of information and resources there. So it's always good to get free information. So now what? What do you do now that we're in January of 2020? You have to determine if you're going to continue offering that leave and pay the emergency paid sick leave or the EPSL. Make sure that you probably are the HR rep, but if you're not, make sure your HR rep knows and what your decision is, and the managers know that, so that if an employee asks about it, that they know whether or not they're paid. We don't want to promise payment if you're not going to do that, or employees coming to work when they're not feeling great, when they could be staying at home because they've been exposed to COVID or whatever. So also check your local laws for other paid sick leave obligations. There are different cities in California that have extended paid sick leave. And obviously you pay your EPSL first if an employee is out for the 6 reasons that are in the FFCRA. And then you pay, if they're still out, then you would go into your company's paid sick leave, which could be just the California requirement of 24 hours, or maybe you have your own policy that's more than that, or maybe you're in Los Angeles where you have to offer more. Just make sure that you look into all that before, while you're making these decisions. And then, of course, with the tax credit, you'll want to work with your CFO, your CPA, to make sure that you get that tax credit for 2020 and then going into 2021. Then also we have the Cal-OSHA's emergency temporary standards. This was effective November 30th. I don't know how anybody heard of this. Obviously I get that kind of information, and so does Teresa and Sarah, but if you haven't heard of this, it is a very important standard that you have to meet. The requirements include implementing a written COVID prevention program and prevention measures, and communicating that plan to your employees. The next 2 bullets here are probably what you've been doing since January of last year, which is implementing that physical distancing, face coverings, and all the other things that you're doing to keep your employees safe. And then of course, training your employees on making sure they protect themselves from COVID. And then identifying, evaluating, and correcting any COVID-19 hazards, investigating, responding to, and managing any COVID infections or even outbreaks. And we'll talk a little bit more about outbreaks in a minute. Reporting, tracking, keeping records regarding any cases that you have. And we've got another law that is going to require you to do that. Complying with all the paid leave obligations that you have, local and as well as state and any federal. And then follow the requirement to maintain employees' earnings for certain, because there are certain employees that maybe they're excluded from the workplace for COVID related reasons, and you do need to retain their earnings, or maintain, their earnings while they are out. But there are some exceptions, but very few. And so these are all part of the ETS. So now what do? Create and implement your ETS plan. There is a model plan available on the Department of Industrial Relations website, and the address is right there. You can get a model plan. It's very extensive. I know the attorney that I work with said this is the most onerous law that California's had in years. So for employers, and so it's very complicated, and it's very detailed, and you have to have it. So also with AB 685, which I'm going to discuss next, that has similar requirements, almost identical in a lot of ways. So you can just merge the two. Just make sure that you have all the documentation for both. And let me go into that. And Teresa, I assume that you'll interrupt me if somebody is putting in the chat box any kind of question.
Absolutely. If you would please, and if I can interrupt you for just a second,
Yeah.
add your questions to the Q&A, and we will make sure that Terri is able to address them. Thank you. Go ahead, Terri.
Okay, so AB 685 is another COVID prevention and reporting law, or something that has to do with COVID. We're all going to be so sick of COVID, not literally, but just sick of hearing this word. And so it mandates employers to provide written notification to employees for if they have been exposed to COVID at work. And so you have 1 business day to do this. And exposure is someone who tests positive, who has a positive diagnosis is quarantined by a healthcare provider. So for example, let's say that you find out one of your employees that their spouse is sick or one of their kids are sick or something. And so that person's been exposed and they're self-quarantined. If they worked with one of the other employees, you know, in a team department or something, then you would have to notify all of them. The notice must be given to all employees who interacted with that employee who is diagnosed positive or exposed on the worksite within 14 days, and then anyone who may have been exposed. So it could be that I had a client once that I did some training on site, and we were separated, you know, we were in one room, but we were sitting far apart, you know, 6 feet apart. And you know, she called me 2 days later and said, one of those employees tested positive for COVID. So she needed to notify me of that happening. So you have to provide employees also with benefits available to them, including the workers' compensation insurance information in case they want to file a claim saying that it was work-related. The option for the option they have for taking COVID-related leave, which obviously would be that EFMLA if you're going to continue that, paid sick leave, any company paid sick leave you have, and then any anti-retaliation or anti-discrimination protection that they have as an employee. And you have to notify employees of also what you're going to do as far as disinfecting and your safety plan and how you're going to implement what the compliant, you know, the CDC compliance, which again, that you're probably already doing that whenever you have an exposure. This mandate does expire on January 1st of 2022. So now what? Review the requirements of AB 685 and, as I mentioned, the ETS, the Cal-OSHA's ETS plan, and ensure that all requirements are met between the two. So to me, I want to be efficient. I want one plan with all the information for both, and you can do that. And then you just want to implement all those reporting requirements and make sure you follow all the safety measures that you've established, and then track your efforts, write down everything, track and document everything. So you have really good records of the communication to the employees and the, you know, the cleaning and just everything that you've done so that you can show that you have kept your environment, you've followed through with all of these COVID related issues.
Terri, if someone does come down with COVID, is it assumed that it happened at the workplace?
I'm going to go into that right now.
Okay,
So,
great. Thank you.
Yes, this is the workers' comp presumption. You know, and just to, I think it depends on the type of work that you have. Like if you're a medical office, if you are a hospital, clearly your employees, if they get sick, are, you know, it's likely they got sick at work, right? Because they've been exposed. But one of the things that went into effect in September, and again, I don't know how people hear about these unless they have an HR professional on staff. And this was the SB 1159, which is the workers' comp presumption. And this applies to employers with 5 or more employees. And it does create with what's a legal term, a rebuttable presumption that if you have a COVID outbreak at work, that it's presumed that the employees that tested positive contracted it at work. And so an outbreak exists if you have fewer than 100 employees, it would be 4 or more employees testing positive at one location. So if you have, let's say that you're a restaurant, you have several locations, or if you have a retail store and you have a few locations, then it would just be that specific place of employment that we're talking about. It would be 4 or more people testing positive. If you have more than that's if you have less than 100 employees. If you have more than 100 employees, it's 4% of the total employees at that specific place. Now, here's the thing is if you have some of my clients, they've got maybe 3 restaurants and employees go between the restaurants, or 3 locations and employees work between the locations. If someone's sick, that employee goes over there. And so then you've got a lot of possibility for exposure. And hold on. And then if the specific place of employment is, you also have to do this if the specific place of employment is ordered by the local health department, the state department of public health, the Department of Safety and Health, or a school superintendent. I don't know if there's any schools on here, but you would be familiar with that. Employers must report to their workers' compensation claims administrator via either email or fax if they are aware that an employee tested positive for COVID, whether they have contracted it or not. And so this is the part that most of us were, a little concerned about, because I'll mention the next slide that it goes back to July 6th. And anybody that tested positive has to be reported to your workers' comp carrier. Now, the workers' comp insurance companies, most of them should have some kind of reporting document. You don't give the employee's name unless the employee is filing a workers' comp claim saying they got COVID at work. But for all non-work related exposures, you still have to report those positive tests. And you just do it without the employee's name. So if you have employee ID numbers, for example, you could put the employee's ID number, or you could just put initials, something where when you give it to the workers' comp carrier, they don't need to have names. And then they can determine if there is a concern or not. And then so you have to report within 3 days. The date that the person tested positive, which would be the date that they collected the specimen for the testing, the address of where they worked, their place of employment during that 14-day period preceding the day that they got that positive test. So again, if you're in different locations and your employees go from place to place, you're going to have more than one location that you're reporting for. And then you have to report the highest number of employees who reported to work at that location where the employee tested positive, where they were working in the 45-day period preceding the last day they worked at that place of employment, at that location. So I hope you already been doing this, because it's a lot to go back, or that maybe you haven't had that many positive tests. And so that would be great, but that's the requirement. So you have to go back to July 6th, as I mentioned. The exposure, of course, could come from several people. So you could have someone who, like myself, I went in to do training. I was there for a couple hours, and just in that short a period of time, I was exposed to someone who tested positive. So it could be a service contractor like myself, or it could be a coworker, it could be a customer, a visitor that came into the establishment. So these are all the people that you need to be aware of, where that exposure can come from. And then this applies whether the employee opens a workers' comp claim or not. As I mentioned, you have to report all positive COVID tests to the workers' comp carrier. Thank goodness it doesn't apply to employees at home. So if you have employees that are working remotely from home and they get exposed to COVID and they test positive, then you don't have the same obligation because they've been working at home. Now, if they're working at home and then they come into the office a couple days a week or once a week, or they were recently there for maybe a team meeting or something, now you've got an issue that you have to report. Okay, this does expire on January 1st of 2023, so we're going to be doing this for a while, and there is a $10,000 fine per instance for non-compliance. So you want to do this. So
Terri, if you haven't been doing it, or people have not, and you were saying, can they report it retroactively at this point in time?
Yes, you definitely want to do that. If you haven't been, because you had no idea this was happening, there are some employers that they know they're supposed to, but they haven't done it because they don't want to have their rates go up and stuff. I'm just telling you, you've got to do this, because in fact, my attorney was telling a story about a client that was afraid to report. And so they didn't. And then they had just like one case, and that's why they didn't want to report it. And then a few months later, I think it was a few months later, they had 40 employees all at once that were, during a short period of time that tested positive. So you don't want to go there. So yes, just do it now retroactively. And again, it's all the way back to July. So hopefully you haven't had that many positives. So now what do? You review all the COVID-19 positive cases that you've had since July, ensure all of them have been reported to your workers' comp carrier, track that through December 31st of 2022. And yes, this goes through 2023. Yeah, I had that wrong date there. And then just retain all your documentation. Again, if you just retain everything you've done, then that helps you if you should ever have some kind of problem, complaint, concern, and just you have some backup there. Okay. Are those other questions, Teresa?
That's all for now.
Okay.
We'll keep you posted.
Okay, so the next one is the California Family Rights Act expansion. This is SB 1383. And if you have 50 or more employees, then you have already been complying with CFRA and or I call it CFRA. So you've already been complying with that. So you don't take a nap yet though, because there are some changes to this, but that's something you're familiar with. So I'm kind of speaking mostly to those of you who have 5 or more employees, because guess what? Now this applies to you. The California Family Rights Act, CFRA, is a job protected time off for employees for their own serious illness, except pregnancy, because our Pregnancy Disability Leave Act covers that. Or it's for caring for specific family members, and I'll go through over who those are, and if they have a serious health condition. It also covers baby bonding. So it doesn't cover pregnancy as in the period of disability from pregnancy, but it does cover the baby bonding portion where the employee just wants to stay home and be with her child, or the husband with the child. So SB 1383 expanded CFRA under the Fair Employment and Housing Act. And prior to 2021, as I said, only companies with 50 or more employees had to comply, but now 5 or more have to comply. So also prior to 2021, and this goes for all of you that have already been complying with this, family members were your spouse, your child, your parent, and your registered domestic partner. But this new bill has added grandparent, grandchild, and siblings. So now you have all of those people that they could take time off to care for if a grandchild was ill and the parents needed help in caring for the child. And also, both parents can take time off together. With FMLA and with family medical leave is the federal leave, and that hasn't changed. But with this one, well, hasn't changed yet. It might, but this one has always said that you could, if you have 2 employees, if you have the couple and they're both working for you, that only one of them can take time off at a time. Now both of them can take time off at the same time. And one thing I want to note here is that if you have to comply with FMLA, this does not change the family members, does not change under FMLA. So this grandparent, grandchild, and siblings is not covered under FMLA. Okay, so now you have to remember that too. And then it also, the new bill eliminated the work site requirements. It used to be that if you had 50 or more employees within 75 miles of your office of each other, that you had to comply. Now there, at least for CFRA, it doesn't change for FMLA, but for CFRA, there is no number of miles. So, and they usually say radius, but the law doesn't say radius. It's just within 75 miles of each other. So if you have a total of 5 or more employees, regardless of where they are, even if they're working remotely, you're going to have to comply with this. So I want to give you some basics. And again, I'm speaking to those of you who have not, who this is going to be new for you, just so you have a little bit of content here. Again, it's a job protected leave. Employees can take up to 12 weeks off for any of these reasons: to care for a child after birth or placement for adoption or foster care. So we usually call that baby bonding. To care for a child, parent, or spouse who has a serious health condition. So now we know we've got the additional family members, but that's what it's been for. Or for your own serious health condition that prevents you from performing your job duties. Also, there's a qualifying exigency related to one's call to active duty or called active duty for certain family members that are in the armed forces. So for example, if someone's spouse is called to active duty and and your employee needs to get some things in place before their spouse goes off to active duty, they may be able to take time off under this leave. You as the employer can establish what the 12-month period is. They can take 12 weeks within a 12-month period, and you can establish what that 12-month period is. I usually recommend a 12-month rolling period, which means that if the employee took time off let's say in September, and they took 12 weeks, I can go 12 months from that period to say, okay, now you can take more, but they can't take more than 12 weeks within a 12-month period. And that period is going to be rolling depending on when they take time. For example, if you have a calendar year, you could have someone take 12 weeks off near the end of the year and then 12 weeks off in the beginning of the next year. And so they would be gone for a total of 24 weeks. And again, they have to qualify for the whole time. It's just that it's up to 12 weeks. And then the employee has to be employed for you for 12 months and have worked at least 1,250 hours in that 12 months to be eligible for this leave to begin with. They do receive financial support. With our California, we have SDI, the state disability insurance. So if an employee is out for their own illness, their own serious health condition, which really just think of it as any illness. If you have a hangnail in California, you're pretty much covered. So if somebody is out for their own medical condition, then they would be filing a claim with SDI to get SDI state disability insurance benefits. If they go out for caring for a family member, any of the family members listed, then they're going to be filing a claim for paid family leave. I wish the state would have called it something else because people think it's a leave of absence where it's job protected. Paid family leave is only an insurance, paid family leave insurance benefit that will compensate them while they are out caring for that family member. So you as an employer, when you have an employee out on CFRA, you have to continue paying their portion of your group health insurance, and they have to keep paying their portion. So if you're not familiar with all of that, this will be something you'll have to establish just a policy so you know what you're supposed to do. But basically, they have to keep paying their premium, and you need to be paying your portion until they are back. And it's only, the approved time, the part that's valid. And then when you're offering pregnancy disability leave, and if you are a 50 or more employees and you have to comply with FMLA, as well as the CFRA, you're going to be coordinating leaves. And you may have somebody out on 2 or 3 of these leaves at the same time, some concurrent, some are running consecutively. So somebody could be out for 24 weeks. And all of that is job protected. So yay. It's just so challenging. So what do you do now? So if you do not have have not had to comply with CFRA, you're going to need a CFRA policy in your employee handbook. If you have been complying with CFRA all along, you want to separate your FMLA and your CFRA policies, because they're going to be a little different, or at least establish where those differences are. You want to obtain or create a leave of absence request form and other documentation so that you can record and track these time off requests. I would definitely get it in writing. I have clients that they'll say, well, no, I never got it in writing. It's just, we never got a doctor's note. We just know that person's out. And I would definitely document everything. It's just going to protect you as an employer. Track all those leaves, communicate with employees on leaves, give them all the provisions of the leave. Just make sure they know exactly what's happening before they go out. If it's an emergency, you can obviously mail things to them or email things to them. And then make sure you train all your supervisors and managers on the company's obligation to comply with CFRA, because they may not know, and somebody asks for time off oh, my daughter is sick or my sister is sick and she's got cancer and I need to care for her. And the manager might say, well, you can't take time off for that, without even knowing. So we want to make sure we educate our managers. So any questions on that, Teresa? You're quiet, so I guess everybody's okay.
Yeah, so far we're good, Terri. I'll make sure I let you know if we have questions.
Great. Okay. So AB 979, this has to do with unrepresented board members. This requires, if you're a public held corporation and you're headquartered in California, it requires you to diversify your board of directors with directors from underrepresented communities. And this is defined as an individual who, and I took this right from the law, who is self-identifies as Black, African-American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or who self-identifies as gay, lesbian, bisexual, or transgender. This compliance deadline is December 31st of this year. So you have until the end of this year to make sure your board has the appropriate members. And the Secretary of State can impose fines ranging from $100,000 to $300,000 for failure to comply. So that's when you definitely want to take a look at.
Terri,
Yes.
this is a layering that also requires these organizations to have females on their board too. That was last year's law. So this is an additional regulation in addition to having women on the board.
You know what, that sounds familiar. And Teresa, I can't speak for sure because I'm drawing a blank on that, but it sounds familiar. So I just can't point to a particular law that says that. I can research it if anybody wants to know for sure, but it just is not coming to my mind that was a law from last year. So I'm going to trust you, Teresa, because you know the laws as well. So listen to Teresa right now, because I can't confirm that. So the next one is SB 973. This is California Pay Data Reporting. If you have 100 or more employees, you're familiar with reporting to the federal government the race, ethnicity, and sex of your employees through the EEO-1 report. California has established a pay reporting requirements to encourage for employers to encourage and ensure wage parity for women and minorities. So you are going to need to comply with this by March 31st by providing an annual report that you'll submit to the Department of Fair Employment and Housing, and it will report that pay data by race, ethnicity, and sex. And my attorney had said that she had looked at the website, I believe it was a couple of weeks ago, and there still wasn't any template or anything for that. So it's, we're getting kind of close here. So it does take a lot of work to do this. So keep checking the website to get this reported. The next one is AB 1963, and this is that HR is now, and some supervisors are now mandated reporters if you have employees that are minors. It impacts employers with 5 or more employees. If you have at least one minor that is an employee, then you'll want to listen up here. It does designate your HR representative, and any employee who is supervising or directly interacting with a minor or minors, if you have more than one, as mandated reporters. They will be need to report child abuse, child neglect, or sexual abuse. And there are several state and county agencies. They just have to report to one of those. And failure to report is a crime. So if you're in HR, there's one more thing you have to be aware of. But at least I don't think any of my employers have minors working unless they are family members or something. So hopefully, but I know some companies do have 17-year-olds, and so that would be the case. You would need to be aware of that. So if you have employees under 18, you want to inform your staff of their obligation to report abuse, neglect, or sexual assault. And you want to provide them with the training so they know what that looks like. And so there is an online training that's offered by the Office of Child Abuse Prevention in the State Department of Social Services. And so you can find that, it's free, and it allows you to train your employees without having to pay someone to do that for you. So make sure you report any issues to the state or county. And then AB 2992 is an expansion of the crime victim leave. You may be already aware, if you have 25 or more employees, that you have to comply with this. It does provide a job protected leave to victims of stalking, domestic violence, and sexual assault. It gives them time off that they might need to get relief. And that relief could be finding safety for themselves, finding a place to live, a shelter, maybe getting their children in a place of safety, maybe getting a restraining order, any of those things that they might need, those things they can get time off. The law doesn't say how much time off, it just says time off. So this expands the types of crimes that may qualify an employee to be eligible for that leave. Includes those that have caused physical or mental injury, regardless of whether any person is arrested for, prosecuted for, or convicted of committing a crime. So that's when you want to keep aware, be aware of. Also, you need to update your policy. If you have in your handbook, again, if you have 25 or more employees, you're going to want to update your crime victim leave policy, and then discuss any employee needs for time off. In my career, I know of one domestic violence issue, but there wasn't a law to protect it, and at the time it was just a unique situation. But I just haven't had that come up. So I want employees to know that if they are dealing with this, because we know it's happening out there. And I just want people to know that those employees to know that we can provide time off. It's not with pay. They would have to use vacation. They can use their paid sick leave, but we want them to know that there are ways, there is time off to protect the job protected time off so they can get those things resolved. But if you have an employee that comes to you and needs time off, you may want to talk to your HR. Certainly, if you are the HR person, they'll talk to you. Your managers will talk to you. Talk to an HR professional or your employment attorney. And certainly don't do anything if you have an employee that maybe is involved in that and you're thinking, oh, this person has so much drama. I just never know when he or she is going to come in with bruises and stuff, and it causes problems and internally. Don't do anything with that employee until you talk with an attorney. Okay, it's a very sensitive issue, and not that you would ever do that, but some people are just like, I've had it with that person. So and then social media policies. I strongly recommend that you have a social media policy in your handbook. You definitely want one if you do your business with social media. So if you have blogs, if you have use Facebook and Twitter and all the different social medias to market and things like that, you definitely want a policy. And so just to touch on this a little bit, private non-government employees, they don't enjoy the same protections under the First Amendment when it comes to the context of employment. So there's no free speech rights that will shield them as private employees from the employer's discipline for sharing information that they shouldn't. So you want to have a good policy that informs employees of the difference between their work self and their life self. And like, for example, personal opinions that need to be expressed on personal social media, not on your company blog or whatever. And then just explaining to them that when they blur that work and life self, that it can impact your business. It can impact the brand, your reputation, things like that. So we want to make sure that that's very clear to them. So make sure that your message in your social media policy does say that there is no free speech in the workplace. I know when I do my harassment prevention trainings, I let employees know that free speech is something that America is known for, but not in the workplace. You can't just say anything or do anything you want. And unfortunately, people, they say whatever they want on social media. Then when they come to work, they kind of feel they lose their filter. So we need to make sure that they understand the boundaries there. So include or update your policy in your handbook, and then have a general policy, and then have a specific policy for social media on your social media channel. What channel is whatever you use, okay? And then just to, as we wrap things up, the California minimum wage increases have continued. We're getting near the end of those unless they make some changes. But if you have 25 employees or less, you should be at minimum $13 an hour. If you have more than 26 or more, then you should be paying your employees at least $14 an hour. I know that sometimes you're increasing people and then they've been there with you for 4 years and now they're at minimum wage. So you have to look at that issue as well, and making sure that people are getting paid a good wage, knowing that 13 and 14 is now minimum. When the minimum wage goes up in California, it means that an employee who is exempt from overtime, so they are in an exemption classification, that their minimum goes up as well. California uses the California minimum wage. It has nothing to do with the number of employees you have. So the minimum for an exempt employee, assuming that they meet all the job requirements, the duties and responsibility requirements, they need to be at least at $28 an hour. So you can see on the third bullet there that they should be making at least $58,240 a year to be qualified as an exempt employee. And again, the salary is just a qualification. So I've had employees or employers ask me about, well, I pay them on a salary, so, and they don't get overtime. So does that mean I have to pay them $58,000? Somebody who's paid salary is just a method of payment. For them to be exempt where they are not earning overtime, they need to fulfill their duties need to meet the requirements of the exemption status, whether it's professional, administrative, executive, there's a few. So make sure that you have that. So this chart just shows you what's coming up next, and then we'll be at 15 by 22 and 23, depending on your size. And then also, looking at minimum wage in your county, your city, there are different minimum wages that have been established by cities, and you want to be aware of those as well in case they are higher. And then the computer professional minimum wage goes up every year as well. It's adjusted. So if you have someone who qualifies, not just if it's your IT guy, but or girl, but if you have a computer professional who meets the standards for that exemption status, then they need to be making $98,000 plus and change a year now. So make sure that you've got that compensation adjusted as well. And then there's new posters that you have to have, and these the chamber sells posters. They have Teresa, you can tell a little bit more about that. I think you have paper and then laminated, right?
Yes, we do. We have both the non-laminated and the laminated posters available. Our supplier is California Chamber of Commerce. Terri, also, I know that one of the resources we've used for our HR manual, which you've mentioned throughout this program, is important for people to update their manual. And I want to make sure people understand that we can also, you can purchase through us an HR manual as well. That is a draft provided by the California Chamber of Commerce that you can then customized to your specific needs, or certainly an HR professional such as Terri Olson can do that for you also.
Yeah, and if you don't have an employee manual or employee handbook, I strongly urge you to have something. Even if you have 3, 4, or 5 employees, you want to document and have that documentation where they sign off saying they acknowledge receipt and that they're going to read it and understand it and comply. You want that to protect your business or your employer if you are the business owner. It's just imperative, and I just can't. So yeah, get the software, do it yourself, have an attorney review it. Just make sure that you have something in place. It's that communication tool that you're going to be able to refer back to if there is any complaint or concern. And, we're a very litigious society. And so, desperate people do desperate things. And sometimes I've seen even a client's best employee that sues them. So because they're desperate for money. So just do things to protect your business. And those posters, I just say, get a new poster every year. Just have a new one every year, because there's some language somewhere on there that's changed. So it's just easier just to get one, and you want one in each location, and get one in English and Spanish. Teresa, do you know if the Cal Chamber has those in other languages, but they at least have it in Spanish, right?
Right, they do have it in Spanish and in English. They may have it in other languages, and if not, I can do some research to where it is. They get to be a little more customized when you don't have the great need. So Cal Chamber really focuses on English and Spanish, but I'm sure that we can find sources for other languages if people have interest.
Yeah.
Sarah has put in the chat the link to the Chamber's website, where you can purchase these through us directly online in the store. And I want to remind people also, if you have questions, either put them in the chat or the Q&A. We're monitoring both, and that way we can make sure that Terri has a chance to address those questions this morning.
Yeah, and also on those posters, you want one in each of your locations. And if you've got this huge plant, you probably need to put them, you just have to have them posted where employees, an area where they frequent, which could be your lunchroom. It's not like anybody ever reads these, but just in case, they're supposed to be there. So we do it because we have to comply. But if you have other locations, and if you have out of state locations, in addition to your California location, I can give Teresa a resource for that as well. Okay. So any final questions before we wrap this up and let you get on with your day?
I think one thing that I would make sure people are aware of is that throughout the year, laws continue to change. And certainly by reading the information that the Chamber of Commerce continues to push out, you can become familiar with some of these. Usually they do not go immediately into effect, but as we learned this year so quickly, things can change and things can go into effect immediately if there's a crisis. So being aware of these things, trying to stay abreast through the materials that we share at the Chamber of Commerce, it can be your best defense against faltering on the law.
Yes.
Terri, are you also offering to new chamber members HR consultations still? I know that was something that you were doing, an hour of consultation to new chamber members. I'm not sure if you're still able to do that with the volume of your work.
Right now, I have like 20 handbooks that I'm updating. I'd be happy to take a call from someone and just find out if they have a particular need or particular question. I can definitely do that. Obviously, it would be, either over the phone or through Zoom. And, but yeah, I'd be happy to still do that.
It's a great resource and one that we've been very fortunate to be able to take advantage of. So thank you.
Thank you.
I'm not seeing any questions in the Q&A or the chat.
Okay.
So we must have done a wonderful job in a blitz of a session.
Either that or everyone went out for a drink.
I think so. Sometimes it's just so overwhelming to have this. It's like drinking from a fire hose. You have to be so aware of everything that's going on. But certainly in California, it continues to change and be really a dynamic, changing environment. So we so much thank Terri for her time this morning. Thank you to Farmers and Merchants Bank for your continued support of these and other programs throughout the year and helping us make sure that information is shared in a timely manner. And if we don't have any other questions, and I'm not seeing them pop up, I just thank you so much for being a part of this today. And to all of you, have a wonderful day, mask up, stay healthy, and we'll see you next time.
Thanks. Bye, everybody.
Thank you.